Welcome to this free immigration help channel. Today is October 7, 2023, and we are getting into the volume 168 of me answering your immigration related questions. As always, before beginning this video, I'm going to mention, as I mentioned in every video on this channel, I am not an immigration attorney. This is not legal advice. All the information provided in these videos on this channel are directly from official government sources like USCIS and of course the Department of State with their visa bulletin. So let's start with the very first question from LOL Miran. I applied for asylum in 2016 in Florida and now I'm living in Massachusetts. My question is, I want to transfer the case file to a state here in Massachusetts. What are the required procedures and do you advise me to do that? Thank you. So LOL Miran, thank you for the question. That's an excellent question. It really is depends. You know, it's hit and miss whenever it comes to especially asylum cases that are in the category where you are waiting for, your interview for quite a long time. Because if you've been subscribed to this channel, you probably remember me mentioning the two different groups of asylum seekers. One group being called in for the interviews pretty quickly, and obviously the positive, the pro of that is that they're called for an interview pretty quickly. But the big con of that is that if the asylum application, initial application is denied, there is no taking this application to court. All right, they are placed in the deportation proceedings, and that's really it. They can't do anything about it. Compared to another group of people where they go by the older asylum, basically process, where if they do get denied during the interview, they do have the ability to appeal and take it to immigration court and go through the court, and chances are much higher, especially if the application was denied. The chances are much higher to get it through the court, approved through the court. And you are in that group of people. So it's not very good that you're waiting for so long. It's, it's upsetting. But at the same time, you do have, that kind of a backup plan just in case. So with that being said, it is a hit and miss if you are transferring asylum case. Florida, whenever it comes to Florida, immigration numbers, especially whenever it comes to asylum applications, they are higher than in Massachusetts. So it can positively sometimes affect the applications. It can negatively sometimes affect the application. Massachusetts, because there's less asylum applications, again, you might transfer the case and you might get interview much faster than you would have been waiting in Florida. Or at the same time, you might be waiting. So it's a hit and miss. Would I recommend transferring it to Massachusetts? Yes, absolutely. I would definitely recommend transferring it to Massachusetts, just because it makes it a lot more convenient, and it's worth a shot. Because of lower immigration number, lower asylum application numbers. You have, an opportunity for your interview being scheduled a little bit faster than you would have been waiting in Florida. Now, whenever it comes to the procedure of changing the location, it's very simple. You want to do two things. Number one is you want to go to USCIS website and fill out I think it's AR11. Let me actually use this as an opportunity to demonstrate some navigation on USCIS website. This is the official government website for U.S. Citizenship and Immigration Services. So from here, we just go to Forms, right here at the very top of the navigation menu. And then All Forms, right here, click on that. And the very first, there you go, AR11. That's just the alien's change of address. And that basically lets U.S. Immigration Services know that you have moved. So you might have already done that, but if you haven't, you definitely want to do that. That's number one. And that basically lets the general, system that now you have a different address. So if you are getting any kind of correspondence, if there is anything that was mailed to you, you will get it in the correct address, instead of your old address. And number two is you want to reach out to the asylum office directly. And if you filed in Florida, then it's either in Miami, they have an asylum office in Miami, and they also have an asylum office in Tampa. Honestly, Miami, now that I'm thinking about it, it's been quite a long time since I've, dealt with the Miami asylum office. So they might have, they might not have it there, but that's where they headed. In one in Tampa, one in Miami. Now they might have more, but that's what you want to find out, where the asylum office is, and you want to send them by mail just a regular letter informing them that you have now moved and you are now living in Massachusetts and you would like your asylum case transferred to the asylum office in Massachusetts. Because the reason why you have to go through this is because whenever it comes to asylum offices, they do have a little bit of a kind of a separate system from USCIS. So whenever it comes to like asylum case numbers and stuff like this, a lot of times they don't show up on USCIS website because they do have a separate system. So you want to make sure that they are also informed that you have moved and your case is now actually in the local asylum office, not USCIS office. But again, please keep in mind that this is really just my personal recommendation. I would personally do that, but again, it's hit and miss. You might move it and you might end up waiting longer. You might move it and it might be scheduled faster. You might move it and you might wait exactly the same time as you would have been waiting in Florida. So it's really up to you. But I think whenever it comes to convenience and just knowing that your asylum case is here locally and you can always call there and you can always schedule an appointment if that asylum office, which a lot of times that's another plus side. The asylum offices that are not as busy as in states like, for example, Florida, California, New York, where there's a lot of volume of applications. Usually they still do have where you can schedule an appointment and show up there and if you have any questions, ask them. So just for that purpose, really, I think that's more pros to transfer the case. Okay, so let me put the link for the AR-11. And like I said, whenever it comes to the letter, asking to change the address is just a straightforward letter, just identifying yourself, putting in your asylum case number, and then putting in the new address, and that's really, it's pretty straightforward. Okay, let's move on to the next question from Neha Yadav. So Neha says, how long can I overstay after I-94 expires and I-539 is pending? Neha, thank you very much. That's an excellent question. So here's the thing. USCIS, they say that a pending I-539 technically is not a legal status. All right. So once your I-94 expires, technically you're out of status. Okay. But because you do have the pending I-539, while it is pending, until you're waiting for the decision of I-539, especially if it is approved, if it is denied, well, it's a little bit, it's a problem. It's problematic. But if it is approved, then that's it. All the time that you were staying here and waiting for the I-539 to be approved, good. Then you're good. Then there shouldn't be no problem. So with that being said, it's up to you. My recommendation usually is that unless it is an absolute emergency that you have to overstay your I-94 and you have to wait for the I-539, then you got to do what you got to do, because that's just, there is no other way around it. But if you don't have to, if it's just a matter of, a little bit of inconvenience or something like this, and you technically don't have to wait up until the decision comes out on I-539 and your I-94 is still valid, then I would not recommend waiting for, decision on I-539 and just maintaining, not overstaying your I-94 just to prevent, not very good situation, potential not very good situation. At the same time, if your I-94 already expired and you do have the I-539 pending, then obviously you don't really have another option. You do have an option, obviously, to leave and not wait the I-539, but I would definitely not recommend doing that, because if you do leave the country before the I-539 is approved, hopefully approved, which in most of the cases they do approve it. It's not really a difficult application to get an approval on. All right, but If you do leave before the approval and you had an overstay on I-94, then it is a problem because the I-539 is considered abandoned, and now you left the country with an overstayed I-94, which is definitely going to be a problem next time you try to enter the country. So you definitely don't want to do that. So yeah, that's really it. But yes, if you did overstay I-94 with the pending I-539, as long as the I-539 was filed before the expiration of the I-94, and no matter how long you've been waiting, whether it's 6 months or a year, I-539, I think as of right now, they take like 6 to 7 months to be reviewed. As long as it is approved, then that's it. All this time that you've been here with an overstayed I-94, you're not going to get in trouble for it because you had you filed your I-539 on time and it was approved. So Neha, thank you so much for the questions. Great question. Hopefully my answer was helpful. And if you do have any follow-up questions, and that goes also for LOL Miran and for everybody else who's watching this video, if you have follow-up questions, don't hesitate. Just post them in a separate comment. Don't respond to my comment within your comment because YouTube does not send me these notifications for some reason. Okay, let's move on to the next question from Tara ZKW Dispatching. Tara, thanks so much for another comment. Appreciate it. So Tara says, hey, thanks so much for advising me to expedite my case at the NVC because I'm getting over age in next 7 months. I'm documentarily qualified along with my parents, category F4, priority date 2008. On the current visa bulletin, the final action dates are 22nd April 2007. It will take a year or longer to my priority date to become final action date. So my question is, am I eligible to request to expedite my case although my priority date is not on final action date? Or should I wait for my priority date to come on final action date because it's a requirement to expedite the case that the visa must be available? Yes, actually, what does it mean? Can you please answer to this? Tara, yes, you're correct. Man, okay, so you're in... Your priority date is in 2008, and right now it is April 2007 for the F4. Let me look at it again. Yeah, April 2007, and depending on which month you are in 2008, but sounds like you know the priority date and you know how to read the visa bulletin. So take about a year or longer, again depending on the visa bulletin movement. So what that means is that the immigrant visa is not available yet for your parents' case. And that is a problem because whenever it comes to expedited requests to the NVC, it's one of the requirements. You have to be documentarily qualified and you have to have your immigrant visa has to be available, meaning your priority date. That's really what it means. When we say priority date is current, that's what it means. It means that the immigrant visa is available. If we're talking about the graph A, if we're talking about the graph B, current priority date means the NVC portal is open. But in your case, since you're already documentarily qualified, obviously we are talking about the final action dates, meaning when the immigrant visa becomes available for the petition. So your situation is becoming a little bit more complicated with that, just because the immigrant visa is not available and it is a requirement to request it with the NVC. Because there is still a long time for this, for the priority date to become current, I would probably, there's really not much we can do, honestly. Unfortunately, there is really not much you can do because to file that expedited request, you have to wait until the priority date becomes current. So unless we see a positive movement for F4, which we haven't seen for quite a long time on the visa bulletin, there is really not much, unfortunately, we can do. Now, thing is, you can try to reach out to the NVC, and you can even send the expedited request to NVC and let them know and saying, hey guys, it's really coming down to where it's very, very close when, my parents' case, when their priority date will become current. and when I will be aging out. Is there any way to expedite it based on that information? Most likely they're gonna say no, Tara, and that's really unfortunate, and I'm very sorry about that. It's not good news, I know. It is one of the requirements. So give it a shot, and really, whatever they respond, most likely it's going to be negative response, but at least you tried, all right? The only thing that is being left is just staying on top of the visa bulletin and checking it every single month, and hopefully we see the positive movement. And if it is, you know, things might change, because we have not seen positive movement on F4 category for a long time. And honestly, I can personally relate, because I do have a petition in F4. I'm petitioning for my brother, and nothing is happening. So when these petitions in certain family preference categories that did not move for a long time, sometimes when finally there is movement, sometimes there is a spike, a good positive movement few months ahead. Like with F1, for example, we've seen like 6 months forward, just like pretty much overnight with the next visa bulletin. The new visa bulletin came up, and it was 6 months ahead of the previous one. It's a possibility, and we're gonna pray for that, and I really hope that this is what's gonna happen. But like I said, give it a shot. Send an expedited request to add to the NVC. Most likely it's gonna be denied, but at least you tried. And stay on top of the visa bulletin, and hopefully it moves forward. And Tara, I really hope it works out for you. I really do. Okay, wow, today's tough questions, tough questions. Let's move on to the next one from user Li3QE. Sorry, YouTube, they no longer show me names, they show me the handles. So the user says, "Hi sir, when is the new visa bulletin coming up? The last month delayed. I'm expecting this to come earlier, and I want to ask if a visa category having the date shown like eligibility area like F1, can they make it current in the upcoming visa bulletin?" Great question. Thank you for asking. So honestly, whenever it comes to F1, it has not been current for a very, very long time. F2A has been current for quite some time, so we might see it being current. And let's actually take a look, because I have not checked in a few days now, see if the new visa bulletin come out, because usually it does come out. There you go. So the new visa bulletin is already out. It must have been out either today, yesterday, because it usually comes out like in the beginning of a month. So there you go, November 2023. I'll have to make a video on this. And looking at the F4, there is no movement once again on the F4, which is sad. On the F1, there is no movement at all. So there you go. The November visa bulletin is already out. And once I'm done with this video, either today or tomorrow, I will make an updated visa bulletin video. I don't think the F1 is going to be current anytime soon, but November visa bulletin is already out. Okay, let's move on to the next one. And thank you, user, I really appreciate it, because if you didn't ask, I probably wouldn't even check for the new visa bulletin, because it's only 7th, October 7th. Usually it's like closer to the middle of the month, but it came out quite early this month. Okay, so let's move on to the next one from Lisa Vega 6132. I am the stepmother of the minor, and her father is already a US citizen. We are doing a form I-912 for her citizenship. My stepchild, who is below the age of 15, do I put my name in part 2 or the applicant's name? Even in part 5, when it asks if the requester is employed, is it asking about me, the parent, or the applicant child? Thank you in advance. Lisa, of course, thank you for asking. Great question. So I'm assuming you're filling out the N600 for child. Honestly, I'm just going to throw it out there. I think it is absolutely ridiculous. They should be ashamed of themselves for charging over $1,000 for a minor child of a US citizen to get the certificate of citizenship. It is absolutely ridiculous. It's a theft. Okay, so yes, absolutely. With your, I would definitely, recommend the filling out the waiver. Hopefully, it is approved. Let's take a look and see what is in part 2 and part 5, just to make sure I can give you the correct information. So let's go to forms, all forms, and again, this you can scroll down, or you can just type in the form that you're looking for, 912. There you go, request for fee waiver. And here's the form itself. I'm going to open it up and let's see. So do I put my name in part 2 or the applicant's name? So let's see. Part 2, information about you, requester. Okay, so the requester is going to be the applicant that is, obviously, if you're filing the N600, the applicant on the N600 would be your child. So it's going to be your child's information here. Now, let's move on to the part 5. Income at or below 150% of the federal poverty. So employment status, unemployed, retired, other. You can select here other and put minor in here. You will have to print it out and write it. So obviously not employed. If you're currently unemployed, are you currently receiving unemployment benefits? No, not applicable. Information about your spouse. Okay, so yes, so because you're filling it out for minor, then it's going to be their information, because you have to keep in mind whenever it comes to the form I-912, the fee waiver, it is it's a sub form that you are sending as part of the application, the main application package that you're applying for. So in your situation, most likely the N600. So the applicant on the N600 would be the requester on the I-912. So hopefully that helps. If you have any follow-up questions, let me know. Again, honestly, it's beyond my understanding why USCIS is charging people over $1,000 in order to get a certificate of citizenship for their child who's technically already a US citizen, because their father is a US citizen. It's a minor child, but it is what it is, whatever. That's the government bureaucracy that we're dealing with. Okay, let's move on to the next one. Again, from user. Sorry, no name for me from YouTube, unfortunately. So user says, hello, sir. Thank you for this masterpiece channel. Appreciate it. So have a question. I come to US by immigrant visa, DV lottery. Okay, cool. So green DV lottery is a green card lottery. You win and you get yourself a green card, and stayed there. Oh, so you're not here anymore for 2 months and back to my country, emergency, without green card. Oh, and I paid the fee there, so my visa is expired. So please come back to US with my visa, because I know I have 1 year like temporary residence and I don't make problem with officer borders. Thank you and hope can help. Okay, that's very interesting question and very interesting situation. So I'm not really that closely familiar whenever it comes to the DV lottery, but I'm pretty sure that when you do go through the interview in your home country for the immigrant visa, you do get the temporary I-551 stamp in your passport. So you get that I-551, you come in here, and it becomes a temporary permanent residence card. And until you are waiting for the actual permanent residence card, which is what we call green card, all right? And that sounds like what you paid for. So if you do have that I-551 stamp in your passport, yes, it is valid, and you can travel back and forth with it, because the first time you entered the United States, it turned into a temporary permanent residence card, which I know it sounds kind of weird, temporary permanent residence card, but that's really all it is. It's until you get that physical permanent residence card in the mail, that immigrant visa stamp, I-551 stamp in your passport, it serves as a proof of permanent residence. So if I'm understanding correctly, and if you still have that, yes, you can travel back and forth in and out of the United States without any problems, as long as that is valid, all right? Now, if that immigrant visa is no longer valid, then you might have a little bit of a situation. In that case, I would recommend reaching out to the U.S. Embassy first and talking to them and asking them, just to kind of understand what is going on, what is happening. But let me know in the follow-up comment if I'm understanding you correctly, and if you have any follow-up questions. But like I said, I-551 stamp, temporary permanent residence card, yes, you can travel in and out of the country, US that is, without any problems. Okay, let's move on to the next question from White Wave 3133. We are CR1 visa. So CR1 is a conditional resident, which is, you would get that through I-130 family reunification, and conditional residence is given to people who are married, I think, less than 2 years. If you're married in less than 2 years and you're petitioning for your spouse, she or he gets the conditional residence. LDR for almost 5 years. 5 years. Married for almost 2. Okay, so married for, spouse should not be separated. What's wrong with NVC? They even denied our depression expedited letter for being away from our spouse. Our spouse doc will be expiring before 6 months. We even paid $1,000 from abroad just to get rush police certificate. Please don't let us stress out, guys. We're serving the country right. Please give priority to us who are married. You prioritized most who are still fiancé. I'm sorry. The government really sucks. Please, we still won't build our family. You know, it is unfortunate, but listen, honestly, whenever it comes to family reunification in general, I think that should be a top priority. You know, it is legal immigrants that go through the process, that do everything right. They pay all the fees. We, because I'm an immigrant myself. You know, I went through this process myself. Paid all the fees, I don't know, probably throughout my immigration, I did at least 15 background checks, at least 10 interviews, at least 5 court hearings, medical examination, very, very unpleasant medical examination, let me say that, but for me, just for me. But that's what we go through. We go through these things, you know, we pay the fees, I mean, tens of thousands of dollars, you know. Look, Lisa, you know, she's filing the I-912 because paying over $1,000 for application, application fee, 1,100 something. I'm gonna find this application fee just so that I, you know, nobody thinks that I'm making stuff up. N600, there you go. N600 application for certificate of citizenship, and this is typically what you file if you, if you have a child who was born outside of the United States and they don't have a U.S. birth certificate. That's what you file, certificate of citizenship. All right, N600. So the filing fee, there you go, $1,170. Application fee. For what? $1,170. And I mean, really, any kind of application that you take, let's take N400. You know, since we started on this rant of government, $640 plus the biometric fee for a total of $725. That's naturalization, all right, which is awaiting everybody. Every immigrant that is in the process of, you know, their immigration ladder, they will be paying this eventually to become naturalized. And then you have the permanent residence, you know, application for permanent residence. You have your medical examination fee. It's thousands and thousands and thousands, and if most people have an attorney, you know, an immigration attorney, that's tens of thousands of dollars. So you pay all of this, you go through these background checks, you do these medical examinations, and once you get all of that, once you became a naturalized citizen, and let's say you want to petition for your son, or you want to petition for your spouse, or you want to petition for your parent or your brother, you have to pay all of that all over again and then wait insane amounts of time. And that's the family. And then we have the politicians who come out on, and they have the audacity. We have politicians on TV that have the audacity to talk about families and how they care about families and how they care about immigrants and immigrant families and all those. It's a joke. It really is a joke. It really is a joke. And the only people who fall for stuff like this are just people that unfortunately don't realize how bad it is for, and the reality of it is it's bad because it is bad for people that do everything legally. You do it the right way, well, you will be paying thousands and thousands and thousands of dollars. You will be going through the background checks. You will be waiting for years and years and years and years. And, and you see still people that wait for years and years. Take Tara. Take the situation that Tara is in. It's a messed up situation. It really is a messed up situation. Things like this I take personally, and it's one of the reasons why I started this channel, because I do want to bring these issues to the light, and I want people to realize where the problems are, and not where we have on CNN or the stupid MSNBC or whatever, the dumb news sources that they don't know what they're talking about, unfortunately. So apologies for the rant that I went on once again, but like I said, I do take these things personally because all the comments that I read from you guys, I can personally relate. I understand how you guys feel. So with that being said, thank you very much for your questions. Hopefully you found my answers helpful. If you have any follow-up questions, don't hesitate to ask them in the comments. Just make sure don't respond to my comment within your comment. Post it as a separate comment, and I will be happy to address it in the next volume. Again, thank you very much for watching. God bless you all, and I'll see you in the next video.